Hello and welcome to the Winter Park Chamber of Commerce virtual webinar series. Today we are so excited to hear from Carina Leeson with Kendrick Law Group, the family division. We are so excited to have everyone with us, whether you're joining us on Zoom or on Facebook. We appreciate you being with us this afternoon. If you'd like to engage in some virtual networking, feel free to do so by entering your name and who you're with in the chat box below. If you hover over the bottom of your screen, you'll be able to find that chat box icon. And if you're on Facebook watching us live, you can go ahead and add those items in the comment section below. During the presentation, if you have any questions for Karina, feel free to provide those questions or ask those questions in the Q&A feature if you're on Zoom. It's again, if you hover over the bottom of your screen, you'll be able to see a gray bar that pops up and you'll see a little Q&A icon, and that will be the area where you will place your question. Same if you're on Facebook, if you would have a question that you'd like to ask, feel free to drop that in the comments below. We are thrilled to be continuing to convene our members and community members through this virtual programming. We started this back in March, and we are continuing to offer this programming by holding these virtual webinars in an effort to help the business community by hearing from different experts throughout the community as they share information and best practices, as well as practical advice. Without further ado, I'll go ahead and introduce our speaker for today, Carina Leeson. She is a family law attorney and collaborative practitioner at the Kendrick Law Group. Karina earned her Juris Doctor degree from Shepherd Broad College of Law at Nova Southeastern University. She has been practicing law since 1999, when she began her legal career as a staff attorney with the 15th Judicial Circuit in Palm Beach County, Florida, in the Family, Civil, and Probate divisions. In 2011, Karina relocated to Central Florida, where she has continued her work in family law. Karina has been trained as a collaborative practitioner since 2010. Through the collaborative process, she has helped restructure families in a private and respectful manner that protects their confidentiality, preserves their assets, and, most importantly, prioritizes their family relationships. Karina's professional mission is to make a positive impact on the divorce process so that the families going through this extremely challenging transition have better results. Karina serves on the board of directors for the Florida Academy of Collaborative Professionals as a board member of Angel of Hope Central Florida, and is a member of the International Academy of Collaborative Lawyers and the Central Florida Family Law Inn. She was recognized on the Florida Trend Legal Elite List in 2020, awarded to less than 2% of Florida lawyers, and was recently certified by the Florida Supreme Court as a family mediator. Karina is a native Floridian and grew up in the Orlando area, where she now resides with her husband and her twin daughters. Karina, thank you so much for joining us today. We look forward to your presentation.
Thank you, Tiffany. I really appreciate those kind words. And thank you not only to you, but also to the Winter Park Chamber of Commerce for inviting me to participate today in your virtual webinar series. So today I'm going to talk about the divorce during the pandemic and what you need to know. So I'm going to share my screen. I've got a PowerPoint that will guide us through what we're going to talk about today. And once we get through that at the end, we'll go through any questions and answers that you guys might have. So let me go ahead and share my screen. Okay, hopefully that's all working. So divorce during a pandemic, what you need to know. So let's start at the very beginning. We'll all remember March 1st, 2020, Governor DeSantis declared a state of emergency due to COVID-19. And it's hard to believe that was 5 months ago. It seems like it was forever ago, and this has just been dragging on, which it has. But yes, here we are in August, the middle of August, and we're still dealing with this. So at that time, you'll recall everything was shut down, and then things started slowly reopening in different phases. Our local courthouses here, meaning Orange County, Osceola County, Seminole, and Brevard, they're all in phase 1 at this moment when they reopened, and there was a flurry of orders that came out from the Florida Supreme Court that then trickled down to local courthouses. I can tell you that the Ninth Circuit, which is comprised of Orange and Osceola counties, they did an amazing job rolling out a lot of different orders in response to the state of emergency and protocols that they implemented right away. A little slower to be implemented over in Seminole County, but they're essentially right now in phase one. So what does phase one mean? Well, the courts pretty much shut down for a lot of things, and what the Florida Supreme Court has ordered the courts to do is to continue to perform those essential court proceedings in person. So if we're looking at what that means, what does essential court proceedings mean? What is essential versus non-essential? Well, what the Florida Supreme Court said is that criminal proceedings, some criminal proceedings, juvenile dependency, domestic violence injunctions, emergency guardianships, Baker Acts, Marchman Acts, but what was notably missing from there were domestic relations matters, meaning divorce cases, paternity cases, relocation cases, those family law matters that need to go forward, those were not categorized as an essential court proceeding. So that really kind of put a halt on that until there were procedures put in place for how those were going to be handled going forward with the use of telephone.
Okay, so it looks like we lost Karina for a second. We'll go ahead and try to get her back on the call here. Everyone just can sit tight for a second. We will get Karina back on the call so she can continue the presentation. Thank you for your patience. Hi, Karina, can you hear us? Hi, Karina.
Yes, can you hear me?
Yes, we can hear you.
Oh, great. Okay, well, I am back on. I apologize for that.
No
I'm not sure if it
worries.
was on my end or what, but here we
No
go.
worries.
Okay, so let's move on to the next slide. Am I still sharing the screen?
You are not. Go ahead and reshare your screen and then we should be good to go.
Great. Okay, is that back on now?
Yes.
Okay, wonderful. Okay, so let's go back to now we're talking about these virtual hearings. And this makes me think of the Verizon guy, Can You Hear Me Now? At the very beginning of this, there was a huge flurry of Zoom trainings by everybody and getting not only the lawyers proficient with it, but also the judges and the litigants. So that was a bit of a learning curve for everybody, and for those who had not been using these platforms previously to communicate. I think everybody was pretty familiar with using telephonic hearings and handling hearings by phone, but this was a whole new world for most of us. So there was definitely a learning curve, and talking about some of the different platforms that various judges use, even within the same courthouse, whether it was by Zoom, whether it was by Microsoft Teams. And then we're talking about, the issues that people were having, whether it's connectivity and the internet, which may have just happened to us, audio visual issues. And then when we're talking about doing these matters and what we used to do in person, we're now having to deal with the things that are missing when you're on video as opposed to an in-person hearing. So personal observation limitation comes to mind. When you're in court, the judge is not only listening to testimony, but also looking at demeanor. They're using many different factors to come up with credibility of a witness, credibility of their testimony, credibility of documents that are being presented. So those are somewhat limited in this fashion, although there are many judges who have now implemented procedures requiring lawyers and requiring the litigants to provide all of that documentation in advance to the judge by way of either emailing that documentation or submitting them on a flash drive or thumb drive, and then being able and being savvy enough to go through all of those documents virtually by doing exactly what we're doing today, which is sharing the screen so everybody is looking at the same document at the same time. So there's just a lot of more steps that need to happen in getting the evidence and the documents. So if there's a document heavy hearing, you're looking at financial documents, for example, those do present some extra challenges. The integrity of the record is another thing that comes to mind. Now we have everybody that is attending virtually, whereas when you're in court, you have typically what's called a court reporter there who is transcribing word for word what the witness is saying from the witness stand. And they're usually a couple feet away from the person who's testifying. Now we're on these different Zoom boxes or Teams boxes. And again, circling back to internet, audio visual issues, it's possible that the court reporter may not be hearing everything. So there's those challenges as well. Some of the pros that I can think of have been more for the lawyers. It's convenient for the lawyers. They can have everything they need in front of them, and there's no travel time. So that bleeds over to a benefit for clients because they are not having to pay for that travel time. So that's always nice. And then, of course, who doesn't love sweatpants? So I think people have been enjoying the fact that they can, be all business from the waist up. So those are some of the pros and cons, although there are many others that we could talk about for a while. So let's move on. This is where we'll get into some fun conversation. Hot topics related to COVID-19. Right now, the big issue that folks are struggling with is the school reopening and whether it's in person versus virtual. So this is it's a really complicated issue. My personal thought is that judges are not really equipped to be making these decisions because of all of the information that really needs to be presented to them. Meaning, are there risk factors if the parents, risk factors to the parents if the children go in person and possibly bring it back home and transmit it? What is the health status of the parents? What is the health status of the minor child? Could transmission lead to severe illness or death? That may require medical testimony. So then you're now having to bring in a medical professional to potentially deal with that issue. Some other factors might be, what kind of work do the parents do? Must either or both of them go to work outside of the home rather than work virtually in order to put food on the table, roof over their head? And what kind of exposure to others do those working parents have? There's also the socialization argument, which, is kind of debatable. I think you'll find people who have arguments on both sides of that, whether it's a benefit or a disadvantage. And then who knows what judges will do with this issue. I have not heard of a ruling on it because most people are choosing, rightfully so, to resolve these issues outside of the courthouse. But taking it in front of the judge, you have to wonder, what are they going to do? What could they do? And then you wonder, what are their life experiences that are going to help them come up with this decision? Do they have children? How are they going to make these life and death decisions? So there's all of those risk factors of going into court on this particular issue. The same has been happening also with school zone designation, and this is not really new to family law, but it is a little bit more prevalent right now due to COVID-19. And parents are arguing, okay, what school zone? Is it going to be my school zone? Is it going to be your school zone? And it also ties into the in-person and virtual issue. So it's a very complicated issue. There's not a really good solution if you're arguing over this. And what I would urge folks to do, especially the people who are trying to make this decision, is really focus on the best interests of your child and your family, taking into consideration all of those factors and more that I mentioned, and really figuring out what can be done and what should be done, understanding that this is a temporary situation, we hope. And that's by all accounts, it's a temporary situation, and what can we do to put a Band-Aid on it for the time being? And hopefully we'll be getting back and there's not going to be a concern. Kids will be back in school. Trust me, I'm hoping for that as well. Again, time sharing. Time sharing is another thing that really became prominent as COVID-19 came onto the scene. And in anticipation of that, what the Ninth Circuit and the 18th Circuit both did is they entered some emergency orders having to do with visitation and time sharing. And in a nutshell, what those orders said: do not have unreasonable restrictions. Regular time sharing is to continue. You might even consider an increase in video conferencing and telephone contact. And the strongest language that was in the order, and again, they were mirror reflections of one another, is that unreasonable behavior by either parent will be severely sanctioned, resulting in makeup time, including summer, including consecutive major holidays. The risk of having attorney's fees and costs sanctioned against you. And if there was some pending matter before the court already having to do with establishment or modification of time sharing, it could have a lasting impact on the court's long-term decision. So they really wanted to proactively let potential litigants know this is not the time to be playing games and saying that you're going to deny contact because of COVID. So that was, something that came out very early on that folks needed to pay attention to. But there's still people who wanted to argue over this, and you may recall there was a case down in Miami, Miami custody case, where the father there successfully argued he should have sole custody because his former wife was an emergency physician in a COVID hotspot. And he won that at the trial court level. It was ultimately overturned. And her time sharing was restored, but you can probably only guess that the amount of time and the amount of money in attorney's fees to argue all of those issues. So that's a pretty big hot topic as well, as the time sharing. So you really want time sharing to be enforced and maintain as much regularity with that as possible, and really implement some additional measures to maintain that. Another hot topic has been financial issues. And again, nothing new in family law, but with respect to COVID, what is new is, unfortunately, people have been furloughed, people have been laid off. So they're now struggling to pay child support and alimony. So what can you do? If you're the payer spouse, there are things that you can file on a temporary basis to ask for relief from those obligations. Again, it's a temporary fix. It's intended to be short term. It does not eliminate the obligations that you owe, but it could give you some short term relief potentially. Um, if this lasts long enough, and when I say long enough, I'm talking about at least a year, there could be additional remedies for you on a long-term basis by way of a formal modification. Let's say in a year you've been laid off or furloughed and you haven't returned to work, or you because you couldn't, the job was either not offered to you, or you're struggling just like many people are right now in finding new employment. There could be some permanent relief available to you in that instance. Okay. So let's talk a little bit about some of the process options that people can use to resolve their family law disputes. And we've kind of focused the first few slides in the first part of this discussion on litigation. And, you know, when I think of litigation, I often think of this clip, this movie, War of the Roses. I think everybody's probably familiar with it, where it was just totally a complete destructive situation where they destroyed not only each other, they destroyed their house, they destroyed everything they had. And that's really kind of the image that sticks with me, and the sentiment that sticks with me with litigation. And I litigated for many, many years, mostly in Palm Beach County. Since I've been here in the Central Florida area, I've really shifted more of my practice to alternative dispute resolution methods, but I definitely saw a lot of high conflict litigation. My thought is, you know, it really should be a last resort and not a first choice for families. It's extremely adversarial. It's a win-lose mentality. There's really, and in my opinion, there's really no clear winner. I do recall winning a hearing or winning a trial and really just leaving the courthouse feeling like, ugh, that just didn't feel like a win. Because at the end of the day, I knew that there were long-lasting implications to that family, those children. And so that really just didn't seem to be the right way to manage family disputes. So another methodology is mediation. And I will tell you that it's better than litigation, but it's generally still based on positional bargaining, which is the what, and not interest-based bargaining, which is the why. So what is the difference between those bargaining methods? Well, the positional bargaining method focuses on, like I said, the what in the negotiation, what people are seeking to get at whatever cost without disclosing their motive, and often disregarding the needs of the other side to get the biggest gain. So, you know, it's that win or lose mentality again. Whereas interest-based bargaining really focuses on the why. It opens the door for an integrative approach to negotiation where both sides work together to find a best solution for parties involved. So again, you're in mediation, and it can be with or without lawyers, but it's still, you're still walking in kind of with the thought that, well, if you don't settle for what I'm offering you here, then I'm going to take you to court. So the threat of being able to go to court that easily and that quickly is kind of looming there, and it does influence that decision-making process, and it can have an impact on who walks out with what. So I'd be curious to know in the chat how many people are familiar with the collaborative process. That is a process that's an out-of-court, voluntary out-of-court resolution process. It's not only interest-based bargaining, but it's also the best option to protect a family's privacy, preserve their assets, and prioritize family relationships. And when we're talking about that process, it's a team approach. It's each of the participants, the spouses, are represented by collaboratively trained lawyers. There are two other neutral, collaboratively trained professionals, that being a neutral financial professional and a mental health facilitator. And with the team approach, you're really offering all the best creative option building that you possibly can bring to a family dispute. And we'll talk a little bit more about that here on the following page. And you may recall too, this, while I'm on this screen, we have for our movie minute, when I was talking about mediation, oh, hold on, my mouse is moving. Mediation, you may recall the movie Wedding Crashers and the mediation scene. And this is where I'm focusing on the fact that the positional bargaining, which is the what. And you may recall in that particular opening scene, they were arguing over the airline miles. And, it was very adversarial at the very beginning, but once they shifted from the positional bargaining to the interest bargaining, at the end, the couple was kind of saying, they were actually fighting over giving the points to the other person. And down here at the collaborative process, I've got Gwyneth Paltrow, and you might remember her famous conscious uncoupling divorce, and that's really the collaborative process. So here's a couple other reasons to choose the collaborative process. One of them is that spouses control the timeline, and you can avoid the courthouse delays. Again, like I said, right now the courthouses are on backlogs. There's limited availability for hearings, and you're really going to move your case forward, save on cost and save on time by looking at these alternative dispute methods and specifically the collaborative process. I can tell you that at the end of last year, and this was pre-COVID, but COVID wouldn't have an impact on this at all. I was able to get through two rather complex divorces. They were, one was long-term, one had complex family business issues, one had equitable distribution issues, there were children involved. We were able to get those done within 90 days. And that is pretty unheard of. And there's not a litigated case, even a pure uncontested case, typically takes longer than 90 days. So I was just unbelievably blown away by how quickly we were able to move their case forward because we had the team of specialists, which I'll get to here on number 3. Number 2, solution-focused problem solving. And again, this is circling back to the win-win strategy and the interest-based bargaining that is employed in this particular dispute resolution method. We're really focusing on, and one of the things that we do right at the outset is find out what the goals of this family are, individually and as a family. And it's incredible to see the overlap sometimes with, with those goals, and using that as a foundation, we then help build all the options to help get each of them to the goals that they're looking to accomplish at the end of this. Number 3, team of specialists, as I mentioned. We have the legal, the financial, the parenting. Oftentimes we'll call in an allied professional, whether it be a collaboratively trained financial advisor, a realtor, a mortgage broker. Those individuals are oftentimes called to come in and provide their expertise. This leads to an extreme amount of efficiency and helping move the case along. I was the chair of the Florida Academy of Collaborative Professionals annual conference this past weekend, and we had a wonderful speaker, Dr. McQuarrie. She's the co-director of the Innovation Labs at the Dolly Museum, and she talked about expert blindness. And expert blindness, it refers to the concept of, for example, if I'm the legal person in the room, that's going to be my area of expertise, is going to be the legal issues. The financial planner, the financial neutral is going to be focused on the finances. The mental health facilitator is going to be the expert in the parenting issues. And sometimes when you're the expert in that field or that industry, you don't see things from the lens of the other experts. And by virtue of having this team of specialists, we really have a comprehensive way of looking at a problem and coming up with those creative solutions that really are tailored for a particular family. Number 4, a focus on the future instead of the past. This preserves family relationships. It promotes co-parenting. And what does that mean? It means that our clients don't have to feel stuck. That's one thing that so many of my clients have told me when they're in litigation, they're waiting for a hearing, they're waiting for a deposition, they're anxious about, what's going to happen and the uncertainty of everything. And there's so many levels of uncertainty in litigation that they really feel stuck and paralyzed sometimes by that. And this really, it takes you out of that, and it helps you give hope to your clients. And that is something that is really important to me for my clients, and giving them that hope that they're going to be in a better place once they get through this and past this. And let's focus on the future instead of the past. And lastly, number 5, it creates what I like to call doable and durable agreements. Doable in the fact that this is an agreement. Once we reach a resolution, this is an agreement that the participants have reached together after extensive and thoughtful negotiation and option building. It means that they can both do it. When you go to court and you have the judge enter an order, it's usually because somebody doesn't want to do something, and now they're being told they must do something. And that's not really a comfortable place for anybody. The durable agreements, they're doable and durable because the participants have come up with them through the collaborative process. And what that means is that you're going to have a greater rate of compliance and cooperation going forward. So those are some really important points to understand about choosing the collaborative process. So what are the common family law issues that folks would choose the collaborative process or choose mediation, or as a last resort, litigation? And here are some of the more common ones. Obviously, we've alluded to divorce, paternity, same-sex LGBTQ issues, parenting plans, which include time sharing and parental responsibility, support obligations, alimony and child support, modifications, pre-suit negotiations, pre and post nuptial agreements, relocation, and distribution of assets and liabilities. So that really kind of concludes some of the hot topics that are going on right now, how they're being handled in the courthouses virtually, and how to resolve some of these things with alternative dispute resolution methods, which in my opinion is a much better way and a healthier way to handle family law issues rather than going to court. But I hope you've gotten some little nuggets of information, and I will end with this quote. So let us begin anew, remembering on both sides that civility is not a sign of weakness and sincerity is always subject to proof. Let us never negotiate out of fear, but let us never fear to negotiate, by John F. Kennedy. And I will open it up. I'm going to stop my share, and Tiffany, I'll turn it back to you for questions.
Wonderful. Thank you so much, Karina. That was an incredible presentation. I know our viewers and community members watching after the fact will be so appreciative of all this valuable information you shared. So thank you for spending time with us today and sharing that with us. As Karina mentioned, it is now time for audience submitted questions. If you do have a question for Karina, feel free to, if you're on Zoom, ask your question in the Q&A box. If you hover over the bottom of your screen on your laptop or computer, you'll see that gray bar pop up and there's a Q&A icon. You can ask your question there. Or if you're on Facebook, feel free to ask your question in the comment section below. We do have a couple that came in via Facebook, Karina, that I will read to you. The first being, do you think having to litigate over Zoom is an advantage or disadvantage when it comes to divorce cases?
And that's exactly one of the things that I was talking about earlier. And I think it depends on what the issue is and who the participants are. I think in some instances it could be beneficial, and it depends on all those factors that I kind of laid out earlier in my presentation. How savvy technologically are the judges? How savvy are the attorneys, if there are attorneys? How savvy are the participant litigants? Because all of those things play into that presentation that the judge is then going to be making a decision on. Is it heavy on documentation that the judge is going to be needing to look at and review in making that decision? Or is it just based on testimony? And is someone going to present better virtually than they would in person? Again, you're not getting that demeanor that you might otherwise get when you're in person over a Zoom or Microsoft Teams platform. So it just really, it's the famous law school answer. It just really depends.
Great, thank you for answering that question. Kind of piggybacking off of that with our next question that we received, what changes to your profession do you think will stay after the pandemic is over?
That's a great question. And Tiffany, honestly, I think that there's going to be a lot that stays in. I was remembering a virtual town hall that our chief judge over in Orange County, Judge Myers, mentioned, and he said in the past couple of months, we've advanced so much with technology, more than we probably would have otherwise over the next 5 years. And that just goes to show you that there was such a aggressive push to bring all of this technology to our court system. And that's just not something that's going to be turned off after this is all said and done. Yes, I do believe that we will be getting back a lot of our in-person hearings, but I think that everybody is now so situated that they can certainly continue where it makes sense, and they'll make those determinations where it makes sense to continue to do some of these things virtually and or telephonically. So I do think a lot of the technology is here to stay, and we're going to see this from here on out.
Absolutely. We are talking about the same thing with, with a lot of businesses, just it's going to stay this way, I think, for the majority or for the remainder of time, basically, just because
Yeah.
what people are used to. And it does come with an extra bit of ease in a way, in some circumstances. So absolutely. So it looks like those were the only questions that we got submitted. Any questions that you do have, if there's any last minute ones that you're able to get in, again, you can ask those in that Q&A feature or in the comments. But just as a reminder to everyone, this will be on our Facebook page as well as on our YouTube page, sitting as evergreen content if you would like to revisit it and hear from Karina again on demand, or share with some friends or community members that need to, that were not able to join us right now live, but are able to join us on demand. I think we got one more question in here. Statewide, any differences in ability to get divorce matters before the judge?
That's a good question. I would not know really statewide because I'm really here in the Central Florida area. But I will say that each courthouse has their policies and procedures. And I would think that depending upon their levels of activity of the pandemic of COVID-19, whether and what and when they're in different phases. I suspect there are other courthouses that are in a further advanced stages because their levels of COVID-19 cases are lower over a longer period of time, such that they are able to move into some of those other phases. I remember, and I'm not sure when it was, maybe about a month and a half, 2 months ago, Orange County actually progressed to phase 2. The metrics for COVID-19 were such that they were low enough for the extended period of time that they went to phase 2, but unfortunately it fell, they rose again, and so they had to go back to phase 1. But I do suspect that there probably are statewide differences based on the locations and based on the level of activity of positive coronavirus testing. But great question.
Wonderful. Yes, thank you for that question. And thank you again, Karina, for answering our audience submitted questions. Thank you so much for being with us today. We appreciate you taking the time to be on this webinar and inform the community and our Zoom and Facebook Live guests, all that Kendrick Law Group Family Division has to offer, and just to hear from the experience that you have and what you shared. We're just so appreciative to have you with us today. So thank you so much for being with us.
Thanks again, Tiffany. And thank you again, Winter Park Chamber of Commerce. It was my pleasure to be here today. Thank you.
Wonderful. And to our viewers, thank you again for joining us. Again, this will be sitting as evergreen content that can be shared, so feel free to do so if there's anyone that missed it. To give you a couple of updates, please be sure to follow us on social media, Facebook, Instagram, LinkedIn, and Twitter. Subscribe to our newsletter if you haven't. That will get you some of our most up-to-date news via whether it's event news or local news pertaining to COVID-19 or any updates that we have from city government as well. So a lot of great information in those newsletters if you'd like to subscribe to those. And then lastly, we have our next webinar taking place on Wednesday, August 26th at 4 p.m. That will be the do's and don'ts of facility disinfecting with Charlie Culver, who's the owner of Speedy Clean. So thank you again, Karina, for joining us this afternoon. We appreciate your time, and to our viewers, thank you for joining us. Have a wonderful afternoon.
Bye-bye.